Greetings, Mr. Petersen.
Good afternoon, Chief Justice. I trust you well this
How
afternoon.
are you well?
I'm well. I'm very well. Thank you very much, Chief Justice.
Okay, all right. You hold a B. Juris and LLB degrees, am I right?
That is correct, Chief Justice.
Both from UNISA.
That's correct.
You were a prosecutor, but only for about 5 years, am I right?
That's correct, Chief Justice.
And have been, if we combine your role as district court magistrate and regional court magistrate, have been a magistrate for about 20 years.
20 years. I'm into the 21st year currently, Chief Justice.
Yes. And you have acted as a judge in both Gauteng and the Northwest.
That is correct, Chief Justice, since 2015 and currently still acting presently the second term in the Northwest.
Very briefly and in your own words, tell us why you believe you should be appointed to this position. What stands out about your legal career that qualifies you for the position of Judge of the High Court?
Chief Justice, as you pointed out, I've been a magistrate for 20 years. And in this 20 years, I've picked up valuable experience. I have been exposed to the district court criminal matters. I have been exposed to the regional court civil matters. And more importantly, I have recently, since 2015, been exposed to litigation or adjudication in the High Court. Chief Justice, at the heart of my career as a magistrate or a judicial officer, I've always sought to strive to uphold the Constitution. I've always had I wish to believe, a work ethic, a very hard work ethic. Wherever I've been assigned, I've done my best and I've allowed my work to speak for itself. And I wish to believe that when I was invited to act the first time in the Gauteng division at the behest of JP Malambo, it was a big honor for me that my work had finally been recognized. During that time, I dedicated myself. I continued with the hard work that is required of a judge, being industrious, sitting the long hours, delivering the judgments that I can as best as I can, and within the timeframes that were required of me. I've always put up my hand, Chief Justice, whenever called upon, wherever assistance has been required. I cast my mind back to my first acting stint where JP Malambo needed someone to assist with full court appeals. I put up my hand and availed myself to assist in that regard. And these opportunities have always given me the opportunity to pen judgments which I believe have made a difference. They involved issues related to violence against children, GBV matters. When I was given an opportunity on the next occasion to do civil matters, in that regard, likewise, I came to the fore, and I believe that I delivered what was required of me. JP Malambo, I must say, gives everyone a fair opportunity in terms of work allocation, and he recognizes the importance of the work that we do. And that, I believe, also was expressed through the fact that I was given an opportunity to attend aspirant judges training, advanced judges training. And when called upon on short notice, I cast my mind back again to a full bench appeal that I dealt with Justice Karelse. I was asked in October of that year if I could assist. It was over 3,000 pages, and given a special appointment in December of that year to attend to the matter. And within a month, the judgment was handed down. In the urgent court, when given that opportunity, and this comes after, I believe, demonstrating one's ability to be equal to the task. the first opportunity I had to sit in the urgent court, Judge Salvi Bakwa, to attend to training in Libya. And I was then called upon on that Thursday when the files were received to take those files upon myself and in the Gauteng division to ensure that everything, that the ship would sail smoothly. And that in addition to perusing those files and ensuring that the following week when the urgent matters are to be dealt with, there would be no delays. And similarly, when I was requested to do the Western local circuit, that's the Potchefstroom and Klerksdorp circuit, Chief Justice, I arrived, and it just so happened that by the end of March of 2018, a government gazette had been published in terms of which the Klerksdorp and Potchefstroom circuit was now to fall under the Northwest. Early on that morning, I received a call from JP Malambo and highlighting the position to me. And I will never forget those words because obviously in dealing with our work, we always ensure that we fly that flag high. And this is what JP said to me, fly that flag high. And this is what I did when I met with JP Leo. JP Leo expressed her views on the work ethic of the Northwest. And I wish to believe that I easily could fit or manage to fit into that work ethic as well. And I've therefore continued to serve not only in the Gauteng division, but also in the Northwest, delivering judgments and doing my best based on this work ethic and the very judicial philosophy from which I move. And that is when I look at matter of Rex versus Hepworth in 1928, for example, it said that a judge is an administrator of justice, not only to see to rules being adhered to, but to see that justice is done. And that has been my mantra, and I believe it's echoed also in the decisions of our constitutional court. So that is what I've always strived to do, and I will continue to do that. There's been lots of sacrifice in terms of the movements that I've had to make between Gauteng and Johannesburg, Gauteng and the Northwest, living in Gauteng. But these are sacrifices that have been made, and there are sacrifices that have been made specifically for the greater good, and that is to serve. You know, in some circles, CJ, I know that at times it is said that being a magistrate is community service. And this is what I dedicated myself for. Being a prosecutor for 5 years, I realized there was an option to become a senior state advocate, but to move to the bench, I realized that is where my passion would be, and that is where I could serve our people. And therefore, I believe with these attributes, CJ, it would place me in a position, I firmly believe, to continue to serve our people in higher office. Thank you, CJ.
Thank you very much. Colleagues, before I call on the JP and the Premier, may I have a list of those who want to put questions to the candidate?
Dodovu. Nyambi.
Schlemmer.
Mlambo. Mogoro.
All right. Honorable JP, over to you.
Thank you. Thank you, Chief Justice. Good afternoon, Mr. Petersen.
Good afternoon, JP Leo.
Yes, you've been telling the commissioners about the experience and work, the work experience in Gauteng. What kind of work have you been exposed to here in the Northwest High Court? And can you just give an indication as to what you did in the Northwest?
Thank you, JP Leo. In terms of the Northwest, just turning back to what I said earlier, that my first meeting with you, you set out the work ethic of the Northwest, and that is that the judges are called upon to be all-rounders. So we deal with criminal matters, we deal with civil matters, and that it is expected of judges to deal with everything. So in the Northwest, JP, I've been exposed to criminal matters both at the main seat in Mabatu. I've been exposed to the various circuit courts extending from Vryburg through to Mukwasi, extending through to Klerksdorp and Potchefstroom and Garankuwa. And then at the main seat, JP, we're exposed to everything. Divorces, civil trials, urgent applications where during the course of the week, any judge is required to assist when it comes to urgent applications. Opposed motions I've dealt with. And overall, JP, these are matters that that I found, particularly in the Northwest, as just a difference to what sometimes we do find in Gauteng. Very often in the Northwest, there are so many issues that call for judgments where it would impact on, obviously, the people and the effect of our judgments on people. So that has been the exposure overall in the Northwest, JP Leo, the extent of the work
Yes,
that has been done.
yes, thank you. Initially, when I inquired from you as to whether you made yourself available for the Northwest, you indicated to me that you would rather be in Gauteng because of your family commitments. Are you able, is that problem resolved?
JP, that I would not call it a problem, but obviously having hailed from Gauteng, one ends up being divided because serving in two divisions, which has been a tremendous journey for me. I had to decide, weigh up family, discuss this with my family, and what the move would be. And in doing this, JP, as a Christian, one obviously, I left it over to God. And what came to mind was Proverbs 3, verse 6. You know, I was leaning on my own understanding of the difficulties and grappling with what should happen. And I left it over to God, firmly believing that God would direct my paths. And ultimately, it's not a decision that was taken lightly. And I wish to highlight that I had applied for both Gauteng and the Northwest, because I believe it is only fair to, in my view, to apply in both divisions, and that ultimately whatever might happen would be the decision of the Judicial Service Commission. But that issue has been resolved, JP, and that obviously I'm fully available to serve in the Northwest.
Yes. Thank you, Chief Justice.
Thank you, JP.
Thank you, JP. Honorable Premier.
Thank you very much, Chief Justice. Can I just get clarity from you with regard to the SABC matter? And I'm referring here to the auction of houses in Mahikeng. My sense is when I look at your judgment, I get a feeling that there is very little social justice, if any, but just a very clinical, narrow, insensitive interpretation of the law, where the effect of your decision would appear to dislodge families from houses, notwithstanding the nature of the relationship between SABC and the lessee. It seems to disregard the fact that these, for about 20 years in many cases, have been the homes of these people. And in a number of these instances, children were actually born and bred in these homes. And with SABC finding itself in the financial quagmire that they find themselves, and just very coldly, people are told that these houses are going to be auctioned in Gauteng on the 29th of May, I think it is. And I was rather disturbed by your decision in this matter, but I'm grateful to have the opportunity to actually put the question to you, Mr. Petersen.
Yes.
Thank you.
Thank you. Good afternoon, Premier. Yes, the SABC matter came before me as an urgent application. So when you do read the judgment, you will see that there was a litany of litigation prior to the matter coming to me. Premier, the matter in essence before me was an application to interdict the auctions that were to take place. So the issue is a very limited issue related to the auctions. Now, in evaluating the matter before me, I'd obviously considered what the applicants had set out in the founding affidavits. What eventually was allowed as an answering affidavit, there's an issue that's been taken with that. And maybe I can pause here to interject. I have been informed that fairly recently an application for leave to appeal has been filed against this decision, and that this would, in all probability, pend before me on the 18th of June. But I would prefer to give some insight or background into the matter and the very nature of dealing with a motion matter or an application. In this regard, it was incumbent on the applicants to set out their case in the founding affidavit. One of the grave difficulties in the matter, Premier, is the fact that the applicants sought to rely on a lease agreement which they had concluded with the SABC. These lease agreements had been extended over many years with the applicants. The SABC, in terms of an agreement with Treasury, was called upon, obviously, as you've correctly pointed out, there are grave problems related to the SABC, but they were required to sell off or dispose of what is referred to as their non-core assets in this regard. The applicants had relied on a constitutional court decision of Mokoni versus Tassos property. And in relying on Tassos, they specifically based their case on a specific point, that they had the right of preemption or the right of first refusals. In other words, if the properties were to be sold, they would have the first right to purchase these properties. What happened with the application papers, the founding affidavit, is that the applicants had failed to attach any of the lease agreements to indicate the basis on which their right of preemption or the right of first refusal, meaning the right, obviously, to indicate that they do not wish to purchase these houses. That was not attached to the founding papers. In the answering papers, the respondent, being the SABC and others, had attached this to their papers, which indicated that whilst the applicant relied on the Mokoni versus Tassos matter, there was no right of preemption in the papers of the applicants. And then maybe to highlight as well, one of the aspects of the case of the applicants is that many applicants had seemingly made offers to the SABC for properties in excess of 1 million rand to pay 60,000 rand or 100,000 rand to the SABC. But I get back to the relief that had been sought. That was to stop the auction. There was no application, obviously, before me regarding any aspects of the eviction of the applicants. And, Premier, you can rest assured that with the application for leave to appeal, in the position of a judicial officer, and I speak broadly from my experience as a magistrate and coming through to the High Court, that you should not be a judge. You should not be a judge if you feel affronted by any application for leave to appeal and forming preconceived notions that you will refuse this. And I can assure you, Premier, when that matter comes before me on the 18th of June, if I'm enjoined to deal with that matter, I will consider the grounds that have been set out in that particular application, and I will apply the law as is required of me, Premier. And if on the application it is found that another court could come to another decision on this matter, then leave to appeal would be granted. In the intervening period, it might be debatable, but the applicants also have resort to Section 18, where one can actually ask for the staying of a particular order whilst the litigation is pending. So I can assure you, Premier, when the matter comes before me, I subscribe to the notion that there are checks and balances. And if I was wrong in this particular decision, and if it is said that it was on a very narrow point, then I will be corrected by a court of higher instance, and I accept that. I've had no sleepless nights in my career when it has come to being overturned, because, Premier, when we give decisions as judges or judicial officers, we don't go out there to give wrong decisions. We go out there based on what is placed before us. And in the climate of an urgent application, Premier, one is to make these decisions in the heat of that moment without the opportunity to do full research and to deal with the matters as it comes before you. But let me give you the assurance that the matter will be dealt with accordingly. Maybe I can just highlight in conclusion, Premier. I love research. I love knowing what's going on in our courts. And I recently discovered that the matter was taken to the Constitutional Court where direct access was sought by the aggrieved and concerned tenants. Direct access was refused by the Constitutional Court on the basis, I understand, that the matter was not ripe to be heard there. So with the leave to appeal process that has now come to the fore, I can assure you it will be dealt with, and if there are grounds to grant leave to appeal, they will be granted, Premier. I hope that answers your question.
Thank you very much, Chief Justice.
CJ,
Thank you, Honorable Premier.
CJ, I beg your indulgence. I want to make your follow-up on the same
Is
question.
that you, Honorable Dodovu?
Yes.
It's your turn anyway, so handle
yes.
everything.
Good afternoon,
Good
Acting
afternoon,
Judge.
Commissioner.
Yes. Just flowing from what the Premier was asking you, are you aware that your judgment has caused a lot of consternation in the Northwest Province? And the communities are extremely angered by that judgment because the SABC has not even consulted the residents there. They feel this way because that building is their landmark. It has produced a lot of important players in the broadcast industry in this country. Your likes of Tim Moody's, Bob Mabena, Shadow Twala, and it becomes very, very easy for the SABC through your judgment to can dispose that kind of an asset. How will you feel that? What will you say if I say to you that you fail to take all of these factors into account when you took make such a judgment, especially of the fact that you are not from the Northwest?
Commissioner Dodovo, as I've earlier indicated, when one considers an application before you, and this is the very nature of motion proceedings, is that one is constrained to the papers that are placed before you, and the specific relief that is sought before you. If I cast my mind back on the papers itself, if it is indicated that the SABC is not consulted, in those papers, the SABC has verbalized that they're more than prepared to consult with the community. So if you're saying that the SABC is not consulted with the community, then obviously this is not an aspect that I'm aware of. But as a judicial officer, dealing with those matters on the papers as such, and the very nature of the papers that were placed before me, obviously...
That's my point, to
yes.
say your inability to understand the peculiarities of the Northwest, of even that landmark building, make you fail to understand that this is quite important for the communities of the Northwest. If you knew the Northwest, if you lived in the Northwest, you would understand what it meant for the communities in respect of that particular building. And in your judgment, you would have taken all those factors into account.
Commissioner Dodovo, maybe if I can clarify this, when we're talking about a specific building,
yes.
In the application before me, what we were dealing with were residential properties. That was the extent of what was placed before me, is the residential properties. There's no mention of a specific building as such, but what we're dealing with are specific residential properties, which are non-core assets of the SABC. And the focus was specifically on those residential properties. And the SABC obviously, in their view, constrained to sell off the non-core assets and then giving an opportunity, notwithstanding the fact that there was no right of preemption, to engage with the families that would be affected by this.
Yes. No, let's leave that one. Let me go to my questions.
Thank you.
The Northwest Province is almost 65% rural, with about 56 traditional councils.
Yes.
Are you familiar with the law that governs the traditional authorities in the country, and specifically in relation to the Northwest in terms of how the traditional councils must be composed? In short, what does the law say in terms of the composition of the traditional councils?
Well, Commissioner Du, I've not engaged on any research on the traditional councils, but there is one specific matter, and this is the nature of matters that come before us as judicial officers, is that we do not profess to know all of the law. And when a matter comes before you, you deal with each matter. And as I've indicated, I am a person who is akin to research. One of the matters that I've referred to in my application is the Matlomi matter. And in that regard, the matter also related to the question of initiation schools, for example, and regulations that were published by the MEC, contrary to an indication that such was to be published by the Premier. And on that occasion, I had the opportunity to do the research and to acquaint myself with what the laws in that regard would be. And I can assure you that if any matter comes before me related to any of the traditional councils, Commissioner Dodovo, that most certainly one goes and you read and you acquaint yourself fully with what the position is. One of the other matters I had was the matter of Lion versus Tsajwa. And in that regard, I was called upon to go and look at the two families and the matter that pended before me, which had a history of going through what we call a full court, eventually to the Supreme Court of Appeal and the Constitutional Court, and coming back to me, where one has to determine ultimately, is there a case for the matter to proceed forward, and who is the rightful family to take control? So the point I wish to make is that one researches these aspects.
I'm
and that
I'm
you
a
do not
bit
live in a
worried
bubble.
if you don't know the provisions of the law, especially when the communities in the Northwest are largely governed by that. There are lots of disputes, whether it's Bakata, Bakafela, Barolombo, Ratsidi, Bapo, Bamokale. These are important disputes that some of them are before the courts in terms of, the traditional authorities there. How do you allay my fear that where I sit, if you are appointed to this position, you will with ease be able and be capacitated to deal with this case, with such cases?
Commissioner Dodovo, the Bakatla matter, for example, just about 2 weeks ago, I had an urgent application on a Saturday evening related to aspects of payments that were due. And obviously, there's a litany of litigation that has gone through, particularly in regard to the Bakatla. I wish to allay your fear, Commissioner Dodovo, that as I've indicated, is that when one deals with a matter of such magnitude that impacts on the rights of the community, that one doesn't simply go into that matter and not do your research on these aspects. I wish to believe that if one were to take an example, that if I had to deal with a matter and the decision is obviously taken on appeal, similar arguments could be advanced in respect of those who have to deal with the appeal matter, whether or not they are alive to the issues and the unique particularities of the community. But as judges, this is what we do. We research and we make sure that we will give to the community a fair hearing. We'll make sure that access to the court is there and that their issues will receive due consideration.
All right, thank you very much. In the interest of time, CJ, and the fact that my questions are limited, thank you very much. I would have loved to go further and further, but it's okay. I'm okay. I'm content. Thank you, CJ.
Thank you, Honorable Dodovu. Honorable Nyambi.
Thank you, CJ. Afternoon, Mr. Petersen.
Good afternoon, Commissioner Nyambe.
You have noted the objection from Rama Tlale Legal Consultants.
I have.
Can you please take us through summarizing your response to the objection?
Yes, thank you. Thank you very much, Mr. Nyambi. When one goes to, if you will permit me, when one goes to the objection that has been raised, it has a history. As I've indicated, I came to the Northwest in 2018 I arrived in the Northwest. The first interaction that I would have had with Mr. Monshiwa, who is the author of the objection, would have been in 2020 when I was allocated, along with acting Judge Nobanda, the application for admission of Mr. Monshiwa. We had certain concerns with the application as such, and it was postponed. On the return date, the judge president had requested that I go to court with an indication to the parties, because in the meantime there had been an application to intervene on an urgent basis by Mr. Nkomo, a local attorney, to remove the applications from the roll, and that through the Minister of Justice, 2 senior judges from other divisions would be called in. That I fully know had transpired. The 2 judges had heard the application, and Mr. Monshiwa's application to be admitted as an attorney sometime, I believe, in August of last year was then accordingly dismissed or refused. There is a leave to appeal. What the outcome is, I don't know. One of the judges was Judge Mbele from the Free State, I recall vividly. And the next occasion that I had where a matter involving Mr. Monshiwa came to the fore is the SABC matter, which Premier has referred to. Now, I just want us to go back just a little bit, Commissioner Yambi. I am in the radar of Mr. Monshiwa on the basis of my interaction on these 2 cases. But when the objection comes, and on a reading of the objection, you will note that Mr. Monshiwa gives a history of where it started. I have nothing against Mr. Monshiwa, but on a reading of the complaint or the objection which he has lodged, there's a major concern in that the Deputy Judge President, and I know that there's litigation pending in Gauteng, where Mr. Monshiwa seeks to review the decision of this body, the Judicial Service Commission, in recommending the Deputy Judge President Hendricks to his position, and then also to have the decision of the President in appointing him reviewed. So that's the first aspect. There, in the objection, there is a complaint about the Judge President herself and the relationship, strained relationship with the Judge President, which Mr. Monshiwa then highlights. Now, on my reading of the objection, what is sought to be done is then to draw this analogy that I am here to do the bidding of my masters. There's a very derogatory terms that are used in the document. I'm not saying that as judicial officers we are sacred cows, as they say. We are open to fair criticism, and that is the beauty of our system and our democracies, that we must accept fair criticism. But in this regard, when we descend into calling a person, I believe you will excuse me if I have it wrong, but to call a person a skopokopo, which I believe is a fool, a crony of the Judge President and doing the bidding of the Judge President, begging questions why I've not reported my own Judge President for trying to enforce herself, her views on me. Let me assure you that judicial independence, independent thinking, and the allocation of work by the Judge President is not done on the basis of achieving some ulterior motive. The objection goes further to highlight that towards the end, Mr. Monshiwa requests as well that, or highlights the Chief Justice as being part of what he calls a cabal, including the Judge President, including, I believe, you might learn, the Minister of Justice, including of all of the judges in the division and certain other acting judges with whom he has had an interaction. So much so that there was a request in this objection by Mr. Monshiwa that the Chief Justice and the Judge President should recuse themselves from these proceedings. So the narrative that is sketched in this particular matter is that we all seemingly are out to get Mr. Monshiwa, and that is the furthest from the truth. I can assure you that in the allocation of work by the Judge President, the interaction with the Judge President and other judges, the division is extremely busy. It's a small division, and there's no intentions to to target Mr. Monshiwa in any way, and any matters that we have dealt with are premised on what has been brought before us, but in no way aimed at targeting him, Commissioner Nyambi.
Do you have any view what might be the motive behind the objection?
Look, I've pondered on what the motive might be, but all I can say is I've sketched you the history of the matter, that I've come in and I've been caught in the crossfire of everything where there appears to have been issues which are long-standing. So what the motive might be, Commissioner Nyambi, I cannot tell you.
Thank you, Mr. Petersen. Thank you, CJ.
Thank you, Commissioner.
Thank you, Honorable Nyambi. Prof.
Thank you, CJ. Good afternoon, Mr.
Good
Petersen.
afternoon, Professor Schlemmer.
You've said quite a number of things already this afternoon concerning your judicial philosophy, which I normally ask the candidates. But you haven't said a lot about the impact of the Constitution on your everyday approach to cases and to the law. Could you elaborate a little bit on that, please?
Turning back to the question, I take inherent in your question is the question of my judicial philosophy, Professor Schlemmer. So get back to this. You would know that there are two trains of thought when it comes to judicial philosophy. We have those who subscribe to judicial activism. We have those who say that there should be judicial restraint. But my view is the following, that when we go to the very heart of Section 39(2) of the Constitution, and what is required of us, not only as judges or judicial officers in the High Court, but also judicial officers in the lower courts, it requires of us to be judicial activists. That's at the heart of it. So in everything that I do, this is my mantra, to subscribe to judicial activism. We must be mindful of the fact as to where our people have come from, where rights were abused, where we did not have the Bill of Rights, where the rule of law did not apply. And foundational to, and this is my view in looking at Section 39(2), is that the rule of law comes to effect there. And it goes one step further. When dealing with judicial activism or approaching your matters from the viewpoint of judicial activism, we look at this through the prism of the Constitution. We look at it at the Bill of Rights, and this is the way we enforce it. If you will permit me, I'll give you practical examples of the way I would enforce this. Taking from the position as a magistrate, it's very limited in that regard. There should be judicial activism in that regard. It's very limited what you can, because being a creature of statute. As a judge, it becomes more because we are able to interpret legislation and we are able to develop the common and the customary law. So if a matter does come before me where the facts would justify that, that is where we would enforce this. A criminal matter that came before me in the Potchefstroom circuit, a young 5-year-old boy was murdered. And looking at the legislation in this matter, I had sleepless nights about this, because upon convicting of that accused in this matter on one of the most horrendous, one of the most heinous murders of that little 5-year-old boy, innocent little boy, it meant that upon conviction, a sentence of 15 years imprisonment had to be imposed. And that surely could not be right. I'd looked at the legislation, looked at my experience in this regard. I deviated from that mandated sentence, and I imposed a sentence of life imprisonment because that is what was required. I can assure you that even now, and the Minister of Justice can confirm that, in Parliament, there are steps taken now to amend the legislation where life imprisonment would be applicable in this regard. But in dealing with and highlighting this particular aspect to you, how I would approach it, just giving you the one example, we must also remember that there is, to a certain extent, also judicial restraint that is required. Now, what do I mean by that? Inimical to the Constitution and the founding values is the question of the rule of law. And that rule of law applies to us as judges as well. And it means that if there is precedent which deals with a specific point, no matter what my viewpoints might be, that I would be constrained to that particular precedent, unless obviously it is precedent that is pre-1994. which might require one to seriously look at whether or not such precedent still finds applicability in our constitutional dispensation. But in our constitutional dispensation, it's always looking at everything through the prism of the Constitution and the Bill of Rights. That is what we strive to do, or what I strive to do. Thank you, Professor Schuler.
Thank you very much. Thank you, CJ.
Maybe just a follow-up on that, Chief Justice.
Yes, sir.
Muiman here. On judicial restraint and your articulation thereof, in a matter that involved the Minister of Finance and the Minister of Finance sought a declaratory order from the court to inform Ogbe that he has no power to interfere in the relationship between the client and the bank, and the court refused to interfere in exercising its discretion. The court refused to make that declaratory order because the view of the court was that in terms of the executive powers entrusted upon ministers, that responsibility lies squarely within them, and that it is a settled law that a relationship between a bank and a client is sacrosanct. What is your view on that in terms of the application of judicial restraint philosophy to that, to what I've just outlined?
Thank you for the question, Commissioner. Obviously, with the court having then found that it could not interfere in that regard, and that judicial restraint had to be exercised. As the judiciary, we are also to be mindful of the fact that the three legs or three arms of state do not operate in silos. But at the same time, we must be very careful to overstep at times and to usurp the functions that would lie predominantly within the power of the executive, for example. So if we say that the court would not have wanted to interfere in that particular regard, without having read the judgment in its totality, I can fully understand that the court obviously would be very careful not to overstep and to usurp the functions and to recognize the importance of that third leg of state.
Thank you, Judge Petersen. Thank you, Chief Justice.
Thank you, Honorable Muiman. JP Mlambo.
Thank you, Chief Justice. Good afternoon, Mr. Petersen.
Good afternoon, JP.
Just one question, since you raising your hand for judicial appointment in the Northwest. You are one of those regional magistrates who hardly ever have more than 10 parthead matters that they have to finalize. You always have less, and I think that testifies to your ability to render service in the High Court. Am I correct?
That's correct, JP. I've always subscribed to the view that we have to ensure that through the work ethic that we keep our matters as low as possible to render quality justice.
Yeah, thank you for that. But the real nub of my question is, JP Leo will tell you she presides over the PEEC, which was conceived by the Chief Justice, about how stakeholders in any region can get together and deal with problems. One of the biggest problems are backlogs in the regional court. I'm mentioning that, but just to test your attitude to the role of the leadership of the High Court in terms of Section 8 in the lower court. What is your attitude to that?
Thank you. JP, I firmly believe if I were to cast it back to you, your role in the Gauteng area, for example, and your oversight over the judiciary there. One of the problems that the regional court is faced with, we might have to revisit the practice directives, JP. Regional courts, with the court roles that they have, are enjoined to set down at least 3 matters per day. Whereas in the High Court, we have running roles to deal with, and I'm speaking specifically from the perspective of the criminal matters. What I have found is that it is important as a presiding officer to have a good relationship with the staff, where that work ethic is instilled in them, And therefore, the importance of every stakeholder literally to come to the party, JP, to ensure that one addresses these backlogs. Because if we do not have everyone buying into this process, then obviously we cannot resolve this particular problem. I know that regular meetings are held. And the question then, JP, is that after each meeting, whether we're closer to resolving these problems. But we need the buy-in of all the role players to
Well,
ensure that happens.
Let me stop you there. Thanks for that question. But I hope, should you be recommended, you'll be able to assist JP Leo in tackling this problem, because I seem to think there's some resistance because this problem is not going away. But anyway, thank you very much for your answer.
Thank you very much, JP.
Thank you, Mr. Petersen. Your excuse, sir.
Thank you very much, Chief Justice. Thank you very much, Commissioner.